Thank you. Hello, everybody. I'm delighted to welcome you today to our annual George P. Smith Lecture. The Smith Lecture culminates the visit of our George P. Smith Distinguished Visiting Professor Chair of Law and Legal Research. And the chair was made possible through a gift by a wonderful graduate of this law school, George Smith, who served for many, many years on our Board of Visitors, is himself a distinguished scholar and teacher who has taught at the Catholic University School of Law. And his vision for this chair was that it would allow us to bring in distinguished scholars from around the world, particularly with an emphasis on the UK and the Commonwealth countries, to spend time with our students and our faculty thinking about the issues that make them excited. And so the chair was inaugurated in 1999 by Justice Michael Kirby of the High Court of Australia. And the first professor in residence was Sir David Williams, the former Vice Chancellor and Rathball Professor of English Law at Cambridge. And since its inauguration, we've had visitors in the chair from Oxford, McGill, National Taiwan University, University of Auckland, University of Sydney, among many others. And so I'm delighted to have the opportunity today to recognize Professor Smith, first of all, and then to bring such a wonderful addition to the pantheon of people who have been involved with this chair. And I would like to ask Professor Mark Janis to introduce this year's Smith Professor, Graeme Dinwoodie. Mark?
I have a very long introduction here that I better cut down very quickly, I think, so we can get on to the business at hand. Well, thank you, Dean. We've had a wonderful series of intellectual property activities here. That's largely the result of the support of Dean Robel and a lot of effort on the part of the Student Intellectual Property Association Executive Board, particularly Leslie Prill is the outgoing president of that. So thank you so much for such a great year. One other little advertisement before I go to the introduction. We're about to launch our Intellectual Property Center, Center for Intellectual Property Research, and its website. That will be coming soon, and all the information we're pushing out to you will be there. It's my great honor to introduce Graeme Dinwoodie today. He's the holder of the IP chair at Oxford at St. Peter's College. He's the director of the Oxford IP Research Center. Really one of the world's leading intellectual property scholars, and if you said leading copyright scholar, that would be right. Leading trademark scholar, leading scholar of IP and designs, leading scholar of international intellectual property, all of that would be right. I would love to tell you at great length about Graeme's exploits as a scholar. Certainly I should tell you that Graeme comes to us from Scotland. University of Glasgow is his undergraduate law degree, LLM from Harvard Law, JSD at Columbia Law, and it goes on from there, just a distinguished academic career. One highlight was the winning of the Padishah Medal for Excellence in Teaching Trademarks, and that was prestigious enough that, as I recall, he had to go to Berlin and wear a tux to accept that, if I'm remembering right. It gives you an idea. What I would really love to do, rather than telling you about his many books, his many articles, I'd really love to tell you about his many exploits outside of the legal academy. And time does not permit me to do that, I'm afraid. Fortunately, though, they're all recorded in a book. And it's a case book, so it must be accurate. Here you can find many, many things about, his behavior in Wrigley Field would be Chapter 3. His participation in the band The Outrageous Wailing Funk Brothers would be in Chapter 4. All of these things leading to trademark infringement liability of some kind or another. I think I should close, though, by giving you an impression of what others have said about his work, which we've also recorded in this book. And I can't read them all, but I'll give you the flavor of them. Gutsy, compelling, intense, a white-knuckle roller coaster ride, says Rolling Stone. It fits right in here. It must be accurate. When I read Trademark Law, I read Graeme Dinwoodie from Paris Hilton. You can only have 3 jokes on I can't decide on my third here. A national treasure, even though he's Scottish, Barack Obama. And my favorite one, because it's really a trademark joke, is Dinwoodie has put the fun back into functionality. Other trademark people would know that. I should point out that this is in the chapter on false advertising in this case. Perhaps that would explain all of that. Graeme is with us today to give an academic talk, and now I will sit down and let him do that. The talk is on global marks in local markets, territoriality in EU and U.S. trademark law. There is no one else in the world as qualified to speak on that topic than Graeme. It's a great pleasure to have him here. Welcome, and I look forward to hearing your remarks, Graeme.
Thank you, Mark, and thank you, Lauren, for those generous words. Mark doesn't tell you that actually, in addition, if you want a summary of all the points at which not only myself but Mark have referenced, if you look at the index to that book, you will find we managed to slip past the editors. In the index, we have included ourselves in the index of the book with all the attributes that we have, and they never caught it, and we're now in the 3rd edition. But thank you for that welcome, and thank you also to Professor Smith for the generous support of my ability to be here for 2 wonderful weeks. And thank you also to the faculty members, in addition to Lauren and Mark, who have made my stay such fun. And thank you also to the students in the various classes that I've attended. It's been great to get back into a classroom. One of the things I was saying to Lauren is Oxford has many, many strengths, but meeting large numbers of people in one big classroom is not one of them. Tends to be sort of very, very small groups you meet, and the energy you can get from a large classroom I had missed, and it was good to be able to get some of that again this week, so thank you. Well, the title of my lecture today includes a phrase that is a complete misnomer, or at least is highly deceptive. There is no such thing in law as a global mark. To be sure, there are global brands. Indeed, for several years, Business Week magazine and Interbrand have published a list of the top 100 global brands. So as a commercial matter, clearly there is something out there that embodies the goodwill behind retail products and services, and that something is global in reach, global in nature. But the intellectual property, the legal rights that sustain those global brands, remains resolutely territorial. It's perhaps trite to say that trademark law is territorial, but like so much that is trite, it is largely true. Indeed, paradoxically, the principle of territoriality remains the foundation of international trademark law. Territoriality structured the Paris Convention as far back as 1883, and even the groundbreaking 1994 TRIPS Agreement really doesn't alter the basic understanding. So, for example, Coca-Cola owns a trademark in Coke for soft drinks that defines its scope of protection in the United States, and a separate UK trademark that separately and perhaps differently defines its rights in the United Kingdom, and an Australian trademark that likewise is governed by Australian trademark law, and so on. Acquiring and maintaining each of those registrations is extremely costly. And to the extent that the US, UK, and Australian trademark rights offer different forms of protection, Coca-Cola trades on a blockbuster global brand in a climate of quite substantial global legal uncertainty. So how are we to reconcile this gap between current commercial reality on the one hand and legal theory on the other? And perhaps also importantly, does it matter that there's a gap between the commercial reality and legal theory? Well, David Kappos, who is the current director of the US Patent and Trademark Office, was speaking at a breakfast in London on Monday. He said it is quite bizarre that we are still operating a 19th century legal model in a 21st century global marketplace. So I think there are certainly a lot of policymakers who think that the question is a very urgent one. Well, in this lecture, what I want to do is briefly explore the dynamics behind 3 different models by which the territorial nature of trademark law is being recalibrated, drawing in particular on the treatment of territoriality in the United Kingdom and European Union on the one hand, and the United States on the other. That exploration throws up what I think appears to be perhaps surprising conclusions. First, many international reforms are actually quite limited in their capacity to create harmonized international protection for so-called global marks. Secondly, many supposedly post-national mechanisms, such as the community trademark in the European Union that I'm going to talk about, are operating in ways that suggest a hankering for the era of national rights, which is likely to cause territoriality to endure, notwithstanding what they want to achieve. And third, and perhaps most surprisingly, hope for a more measured revision of territoriality might lie in a very unexpected source, namely the bottom-up evolution of national trademark law principles and doctrines by national courts. Before I set out the three models that I think support those three propositions, I want to address an important preliminary question, which is, why is the revision of territorial assumptions in trademark law so important? Other intellectual property laws are also territorial. Indeed, most law is territorial. How are the challenges that confront trademark law any different from those that face legal relations generally? After all, globalization, free trade, and the internet have altered the climate within which all law operates. Thinking about that question is, I think, extremely instructive, forcing us to think about what it is that makes trademark law particularly different will help us assess the choices that we have to confront in how to revise the principle of territoriality. So I've argued before that statements about trademark territoriality in fact mask a variety of different though related propositions. Territorial philosophies separately affect rules regarding the scope of rights, applicable legal norms, acquisition of rights, and enforcement of rights. So in the United States, the scope of trademark rights at common law remains defined by the territory in which the mark is used, which I'm going to talk a little bit more detail about in a moment. Trademark laws, the group of legal norms that determine the availability and scope of trademark rights, are largely territorial also. They are promulgated primarily by national lawmakers, whether legislators or courts, although sometimes they occur with an eye to international norms or international principles. Acquisition mechanisms are also territorial. Territoriality requires the producer to obtain separate rights for each territory, normally a country, in which it desires protection, and historically that required going separately, making a separate application in whatever language, whatever fees, to each national office in which rights were sought. Finally, enforcement mechanisms are territorial. A U.S. trademark confers rights only within the United States, extraterritorial for enforcement being very much the exception. And unlike causes of action such as contract or tort, any trademark infringement action based upon foreign rights, non-U.S. rights, must be brought in the country where those rights were granted. Well, what is the value of disaggregating those 4 or 5 different principles, all of which have a territorial component? I think when you do so, as I'll show in a minute, it becomes apparent that different rules of territoriality possess that territorial character for different reasons. And this then becomes relevant to the model which might be most effective in reforming the commitment to territoriality. So let me illustrate the point by first focusing on the United States. Historically, within the United States, the scope of trademark rights has been defined territorially. So, for example, the U.S. Supreme Court in 1918 decided a case United Drug versus Rectennis, which is still good law. And what happened there is, in 1877, the predecessor of the plaintiff started using the mark Rex to sell medicinal products in Massachusetts. 6 years later, a druggist in Louisville in Kentucky started selling blood purifiers, somewhat similar product, under exactly the same mark Rex, but only sold them in Louisville. Well, under U.S. law, the person who gets rights is the first person to use the mark. However, the Supreme Court held that the trademark rights of the producer from Massachusetts who'd used 6 years earlier did not extend to Louisville. Indeed, not only could the Louisville producer keep using its mark, it could exclude the Massachusetts producer from selling and using the mark in the Louisville market. What the court did was it recognized the coexistence of 2 trademarks, each defined by the territory in which it was used. One was a Massachusetts-used mark, one was in Louisville. Why did the court do that? Defining the scope of trademark rights territorially actually flowed logically from the intrinsic purpose of trademark law to avoid consumer confusion and stop diversion of trade. In the Louisville area, customers associated the mark Rex with the products of the Louisville, Kentucky producer. If the Massachusetts merchant were able to sell its goods in that particular area, consumers would be confused into thinking the product was in fact that of the Louisville merchant. Thus, in the United States, the metes and bounds of trademark rights are defined by, among other things, and not exclusively, the territory in which the mark is used. And that is grounded in the intrinsic purpose of trademark law. Now, federal registration principles have now been superimposed upon those common law principles of territoriality. So to encourage the development of a national economy and facilitate enforcement, Congress in 1946 enacted the Lanham Act, and federal registration under the Lanham Act amounts to constructive nationwide use of a mark. Without going into the details of that interaction between the common law and the registered rules in principle, note the contrast with common law rights. Registration systems reflect in relatively greater part the role of trademark law as an instrument of economic and industrial policy. The territorial character of the Lanham Act registration scheme is thus due more to the reach of the policymaking or enforcement authorities, the U.S. federal courts, than to the intrinsic nature of trademarks. Likewise, consider the other territorial propositions I mentioned a few moments ago. The territoriality of trademark laws, trademark acquisition practices, trademark enforcement mechanisms tend to reflect a political notion of prescriptive power and practical concerns about the power to enforce laws. These rules have their territorial character because of their connection to political institutions with territorially defined sovereignty. Thus, to conclude and bring that together, some aspects of territoriality are rooted in social and commercial practices that dictate the reach of the brand, the reach of the reputation, and other aspects of territoriality are a function of political or policy-making authority. Why does that matter to draw that distinction? Well, in an era of global trade and digital communication technologies, social uses are less territorially confined. They are less commensurate with the nation state. Despite that, however, economic policy-making and political institutions are still, even in a global era, essentially nationally defined. If the territorial character of a rule reflects the intrinsic purpose of trademark law, trademark protection might itself inevitably mutate as the notion of territoriality changes in line with social changes. If, however, the territoriality of a doctrine mirrors the scope of a political institution, efforts to revise the doctrine are first going to have to focus on revision of the political institution. So with that observation in mind, let me turn to the three models that we can see for internationalizing trademark protection. First of all, using international institutions. This is the most obvious model, and we've been pursuing it since 1883. International law mechanisms to ensure protection for mark owners on a worldwide basis. The Paris Convention, which is still the foundation of all of this, embodies a couple of devices that reflect this approach. Most notably, the national treatment obligation that requires that trademark applications be available to nationals of foreign countries on the same terms as locals. However, national treatment is in fact the corollary of territoriality. It allows foreigners to apply for marks, but only on the same terms as locals can apply for the marks, and those terms can vary throughout the entire world. To be sure, the Paris Convention created other mechanisms, such as the priority rule, which are intended to facilitate the acquisition of multiple national rights without opportunists coming in to misappropriate registrations. But the rights in question, even when the priority rules are applied, are rights that are obtained and secured under each country's respective national laws. As a result, despite the Paris Convention, the cost of maintaining all these national registrations is still very high, and the laws may still be very radically different under which your protection is available. Although Paris, therefore, did little to harmonize the substantive norms, the TRIPS Agreement in 1994 did quite a bit more, and there are more detailed provisions regarding trademark laws in the TRIPS Agreement. However, the TRIPS Agreement fundamentally, although it forced the convergence of trademark norms, still remains wedded to the principle that trademark rights are territorial. So even if the rules that determine the existence and scope of rights became a little bit more similar throughout the world, applicants still have to go through the process of obtaining these national registrations. As a result, the costs still remain very, very high if the applicant, such as Coke, wishes to obtain protection for a mark on a worldwide basis. Now, there has been a partial answer to that dilemma for over a century, which may make the lecture seem a little out of date, but it's only partial. The Madrid Agreement which was concluded only 8 years after the Paris Convention, allows a trademark applicant to obtain a bundle of national registrations through a single application that's processed through the World Intellectual Property Organization. Now, for reasons that we don't need to go into, the United States took close on just over a century to join the Madrid system, which it did in 2003, and in fact, the U.S. applicants are now using the Madrid system quite substantially. Last year, Madrid applications from U.S. applicants increased 30%. But the Madrid Protocol itself is still only a minor modification of the territorial model. The international procedure is used to facilitate applications for national rights. The applications are still assessed under national laws. You still get a bundle of national rights that you have to maintain at the end of the day. The primary benefits are gains in efficiency, in the costs of obtaining those rights. But costs are only part of the equation. Because the applicants remain subject to different national laws, different authorities may take different views as to whether you should get rights. And that's not simply because of approaches that differ in legal interpretation. Rather, because each national authority is asking itself whether its consumers, its public in its particular country, regard the mark in question as a source indicator rather than, for example, a descriptive term, it is making an assessment of protectability through a local, culturally specific lens. The same is true when national courts are asked to enforce those rights. Analysis of confusion and hence of liability turns on the nature of the local market. So the basic proposition that trademark rights are territorial, meaning in this context national, remains largely intact, despite evolutions in Paris and TRIPS and the Madrid Agreement that have, to some extent, reduced the costs of legal uncertainty. So a second model for moving beyond territoriality rather than just relying on international treaties involves a regional trading bloc creating unitary trademark rights throughout a free trade area. And the most ambitious effort in this regard is the European Union's Community Trademark System, the CTM. And since 1996, interestingly, United States companies have filed a greater number of CTM applications than any other country, actually double than the next largest country, which is Germany. The CTM system places great emphasis on the unitary character of the CTM. The mark is valid for the entire European Union or it's not valid at all. The unitary character of the CTM presents opportunities for substantial cost savings for producers in the EU because you can get rights throughout the entire EU with a single application. And it's a single right this time, not a bundle of rights. It was thought that, in fact, you'd be able to maintain that right through use anywhere in the European Union, not necessarily in all of the countries. And you could obtain relief, since it's essentially a federal right, for the whole of the EU with one single enforcement proceeding. However, the strict approach to the unitary principle that is at the heart of the CTM, and therefore at the forefront of the effort to deal with the problems of territoriality, has run into some problems. And I'm going to mention 4 of these in a second. And I think what they all show is that the introduction of the CTM was essentially a political change in EU law, rather than reflective of changes in the market, changes in the culture in Europe. And I think that discrepancy suggests how likely it is that the CTM is to really get over the problems of territoriality. So let me turn to those 4 areas of EU law where the pressure on territoriality is proving perhaps too much for the system. The first one involves distinctiveness. Like all trademark applications in most countries, a registration is only granted if a trademark passes both absolute and relative grounds for objection. Relative grounds involve a relationship to some other right, normally another earlier trademark. Absolute grounds look at the mark on their own terms. So Article 7 of the regulation requires that a mark be distinctive, that it likely to be likely going to identify source. So Exxon for gasoline is protectable as distinctive. Unleaded would not be. Viscosity reducing would not be. So to secure a community trademark, the applicant must show that it passes both the absolute and the relative tests. So what this means is that if there's a single similar mark, even in a single country, that's been registered prior to the CTM application, the CTM is going to be denied. So I want to market in Europe, and there is a 1997 Greek registration that is similar. My CTM fails. That is the inevitable result, in fact, of the terms of the regulation, which defined earlier marks as including every national registration, not just CTM registrations. And at one level, this regard for earlier national rights makes perfect sense. From the point of view of the Greek consumer, if I got a CTM, notwithstanding the existence of the notwithstanding the existence of the Greek registration, Greek consumers would be confused by my use of the CTM in Greece. By the same token, however, there's a tension there with the political objective of the regulation, which was to forge a unified market and to allow traders within Europe to expand the scope of their trade to the entire EU. Interestingly, United States law has resolved that tension through rules that allow the coexistence of marks within a single integrated market, and they've developed remedial rules that I'll come back to later that protect local markets even where there is a senior user with nationwide or federal rights. The EU Trademark Office has also taken the position that absolute validity must also be assessed by reference to each of the member states. Thus, if a term is descriptive in a single member state of the 27, then it will be denied registration as a mark. Now, of course, as those of you who have done trademark know, when a mark is descriptive, it can still become a trademark through proving secondary meaning or acquired distinctiveness over time. But the courts in the EU have held that to overcome that hurdle, you must show that it has acquired distinctiveness in every country in which it was initially descriptive. That effectively means you might have to show that in all 27 countries, which is a very hard hurdle to overcome. And the courts have rejected the idea that you instead should ask the question, is there secondary meaning in the European Union? The question they want to ask is there secondary meaning in each of the 27 member states of the European Union? A review of the regulation that was just published last month has actually suggested that this should be revised. But in the interim, what we see, therefore, is basically an unwillingness in the courts to view the rules in this area through a political lens, but sticking very firm and fast to the issue of the intrinsic purposes of trademark law, of consumer confusion, and keeping that as their primary guide. Here, interestingly, I think the lessons of how to reconcile the intrinsic territoriality of goodwill with the political reality of the federal scheme might, however, run in the other direction, this time towards the United States. US courts tend to assume a monolithic national consumer base with only minor doctrinal entry points that allow for analysis of local variation, such as defining the scope of common law rights or perhaps the relevant universe of survey participants for determining confusion or secondary meaning. But of course that's not true, even in the United States. One of the byproducts of globalization has been a re-emphasis on local values, as increased immigration patterns diversify the country, as the internet allows a reconnection with local cultures purchased from afar, and perhaps even as individual groups construct their lives quite consciously in ways that fight what they see as the homogenization of globalization. One wonders, in fact, whether the US courts have bought too much into the idea of a political goal of a national integrated economy and have sacrificed the differentiation of markets to which the intrinsic territoriality of trademarks has long alerted us. Regard for discrete local markets is raised, but very often subconsciously ignored in the US decisions, and there has been criticism of the older decisions that actually wanted to alert it. Now, I say this, I should say, with all awareness of the fact that trademark law, in any instance, in any litigation, is a rough judgment about what exactly consumer confusion is. But it's clear to me that I think the US courts are viewing their market in a much more integrated fashion in the rules than reality, whereas you may see the European Union actually is the flip of that. Second area where the territoriality is causing a problem in the European Union is in the context of dilution protection. In the European Union, marks with their reputation, what the US law calls famous marks, get protection against dilution without having to prove confusion. And the trademark regulation explicitly states that this additional protection is available to marks with a reputation, quote, in the community. In a case called Pagel versus Tiromilch, the applicant's mark, which was Pagel for drinks, had a reputation in Austria and absolutely and utterly nowhere else. Yesterday, one of your Austrian LLM students managed to identify indeed Pagel was a well-known mark, and I don't think anyone else in the class knew, so we had a survey that confirmed that Pagel has a reputation in Austria and nowhere else. But the owner wanted to use CTM to secure relief throughout the European Union. The question was, did it have a reputation in the community? Austria, after all, is part of the European community. Well, the Court of Justice held that to be protected, you had to have protection in a substantial part of the territory of the European community. And then it said that Austria might constitute a substantial part of the community, and sent it back to the Austrian courts to work out that question, whether they thought Austria was a substantial part of the European community. What you see here is clearly an inconsistency between the approaches taken by the EU courts to the territorial aspects of their distinctive analysis on the one hand and their reputation analysis on the other. And it's been explained, if you read the European scholarship, by the simple mention of the phrase "in the community" in one provision but not in the other provision, and I think that's just way too simple. The entire scheme was enacted against a backdrop of a particular commitment to territoriality, and there is a need, I think, to explain the inconsistency in light of that commitment. Decisions about territoriality do, as I think the US courts have seen for a century, recognize more than simply decisions about the intrinsic purpose of trademark law, but also incorporate decisions about politics. Third issue in which the EU courts have had problems is the question of genuine use. This is a case pending at the moment before the Court of Justice. Even in registration-based systems such as the European Union, use must be made of the mark within 5 years of application, or the mark is revoked for non-use. And that's to prevent what is known by trademark lawyers as the warehousing of marks, the accumulation of deadwood on the register, neither of which are meant to be good things. Thus, Article 15 provides that a mark will be revoked unless it's put to genuine use in the community within 5 years. And one of the benefits that was touted of the CTM was this would allow you basically to use in one country and expand whenever you wanted to the other 26. However, that proposition is now being tested by a case coming up from the Netherlands and the Benelux courts, who have held that use in a single country, you should see the echoes here of Pagel, use in a single country cannot amount to genuine use in the community. And there again, there are arguments in both directions, parsing little details in the regulation, and there's arguments based upon whether something was said in a minute of a meeting in 1992 and whether that should be admissible because it was secret, and that's the debate going on in Europe at the moment about how to resolve this question, which I find highly unilluminating. I would suggest that we might understand what's going on more if the participants would recognize that the issue about the territorial scope of the use that's required to maintain a registration reflects a broader set of impulses. Some derive from political concerns and some derive from the purposes of trademark law. So is the use requirement simply a function of trademark policy, of eliminating deadwood and freeing up marks for others? Or is it designed to create and further a political union, perhaps in advance of a commercial and social reality of such a union? So recital 2 of the regulation talks of actively creating the legal conditions that allow trade to become regional rather than local. If the territorial scope of the use requirement is indeed a function of political policy, then the challenge must be grasped and the analysis has to be conducted in those terms. The courts should effectively, as in fact American courts do, erase the political borders from the map of Europe. But for reasons intrinsic to trademark law, of course, it might be reluctant to do that. The final issue in which EU law has struggled with this question is the scope of relief. Another benefit of the CTM was meant to be that you could obtain relief for the whole of Europe in a single proceeding. Recall that one of the manifestations of territoriality is that enforcement of rights can only be secured from the courts of the country that granted the right. So the CTM appeared to get round that problem. It created so-called community trademark courts sitting throughout the EU, although in practice these community trademark courts are the judges in national trademark courts wearing an EU hat. And the regulation also created what's called international jurisdiction. That's like the World Series. International there means European jurisdiction, which gave those CTM courts who were exercising jurisdiction based on domicile power to adjudicate EU-wide infringements. And it seemed like this was a way to EU-wide relief. Well, there's another case before the ECJ at the moment that tests the limits of that proposition. In the case of French Republic versus DHL, the plaintiff owns a community trademark for web shipping, goodness knows how they got it, for services for the collection and delivery of mail. DHL used the same word to designate its internet-based express mail management service. French court finds infringement. The question is, should it award EU-wide injunctive relief? Well, a few months ago, the Advocate General of the ECJ, who's still waiting a court's opinion, issued his opinion. According to the Advocate General, an injunction should have EU-wide relief unless the claimant does not assert infringement of his mark outside a particular territory, or infringement has occurred in only a particular group of member states because the existence of confusion is dependent on a specific linguistic usage in those territories. Remember, we were talking about France. The approach adopted by the Advocate General is a commendable attempt, I think, to reconcile the political territoriality of the CTM, which allows unitary rights to be adjudicated by essentially federal courts with EU-wide jurisdiction, EU-wide remedial powers, with the intrinsic territoriality of trademark rights in Europe, which frequently will operate differently in different markets, causing infringement and confusion in some, but not in the others. Now, there are clear parallels here to what the US approach was through 1950 through the end of the 20th century, particularly in cases such as Don Donuts, where the federal court in New York recognized the exclusive right of the plaintiff to use throughout the United States, but limited relief to those parts of the United States in which both the plaintiff and the defendant were trading, and therefore in which confusion was likely to occur. But there are some differences. In DHL, the argument confining the injunction to France was not that it was the only place where the defendant was using the mark, though that actually might have been the case on the facts, but rather that different markets in different countries within the European Union might actually lead to different conclusions on confusion. That does seem somewhat at odds with the unitary EU-wide priority. In Don Donuts, in contrast to the United States, as soon as the senior user who held the American registration expanded trade, it would have been able to secure a US-wide injunction. Moreover, the Advocate General's approach places too much power, I think, in the hands of the plaintiff. His approach creates risks that a plaintiff will cherry-pick and define litigation in ways that give it a chance to take 2 or 3 bites at the cherry to secure relief. And you can see this dynamic in a case called Rodeo Drive, that is a French-German dispute. In that case, the plaintiff mark owner owning a CTM sues Christian Dior in France for infringement of the CTM for using Rodeo Drive for sunglasses, and Christian Dior prevails, found not to be infringement. Good. Now we can sell in Europe the CTM, we're not engaging in infringement. The licensee of the mark owner in Germany then brings the same claim against the same use by Christian Dior in Germany, involving exactly the same marks. German court says this is a different case. They're French, we're German. And they find infringement. Now, we would have found res judicata in that circumstance clearly, but what you end up with is essentially the mark owner was able to start trying to have several goals, and as soon as it won one, Christian Dior was in a little bit of trouble in terms of trying to sell in the European market. That's the type of opportunity that under the Advocate General's approach in DHL might occur more frequently, because he appears to put the ability to structure the claim in the hands of the plaintiff. Those decisions, DHL and Rodeo Drive, also, however, highlight the limits of the CTM in imposing a rule of political territoriality without fully instantiating the political institutions or methods appropriate to effectuate the commitment to political territoriality. Because community trademark courts are actually national judges sitting in their national courts wearing EU hats, they tend to analyze questions of consumer association and consumer confusion as national actors. French community trademark courts will, as they decide 7 questions of French trademark law, followed by the one at the end of the day on CTM, apply or view things through a French lens. German courts would do the same through a German lens. If one elevates the intrinsic territoriality of trademarks, this makes sense. They're asking whether their own consumers will be confused. But if the supra-territorial commitment of the CTM is in fact a political goal designed to create an integrated commercial and political union of 27 countries, the question that should be asked by both courts is whether a European consumer would actually be confused. Because the national courts have been simply commandeered in aid of the European project, the EU legislature has provided neither the political infrastructure nor the sufficient guidance to make that shift. Now, of course, in the United States, federal judges do think of themselves essentially as American shoppers, and if you don't believe that judges actually think of themselves as shoppers, you should read some opinions on, for example, Justice Scalia and Daystar sort of explaining how he goes about video shopping. They really do think of themselves as shoppers, notwithstanding the fact they're meant to be deciding sometimes points of law. But in the United States, the political territory and the commercial and social territories are relatively congruent. In the European Union, this is not the case. We have created a legal fiction of a unitary market, but the reality of the European market is really very different. Recognizing the character of the territoriality-related issues might help identify the further reforms that are necessary if we are to move beyond territoriality. If the EU wants to elevate the importance of the intrinsic territoriality of marks, of trademark law, it must face up to the need to balance that concern with the political imperatives of a united Europe. And that is going to involve the development of doctrinal devices such as the ones we saw in the United States through the course of the second half of the 20th century. If instead the purpose of the CTM is that marks are meant to move in advance of markets, then lawmakers are going to have to provide the guidance and the political infrastructure to make that happen, whether, most notably, EU-level courts, or requiring courts to ask the question in terms of the European consumer instead of the national consumer. Because in Europe, the gap between intrinsic commercial territoriality and political non-territorial aspirations is too wide to be bridged without much more aggressive political changes, and the appetite for those changes, at least I would judge at the moment, does not exist. That sounds all rather pessimistic. We have an international model that only goes so far. We have a European model that is struggling because of an identity crisis and a lack of political will. So are there other options? And that brings me to the third model, which is tied in greater proportion to the intrinsic territorial purposes of trademark law. And drawing on social and commercial patterns and changes rather than political changes, I think might cause reform that is more evolutionary, but more likely, in fact, to be lasting. And I'm going to give one example in particular of this, but I'm going to suggest at the end 2 or 3 other areas where this might happen. The principal example to which I'm going to refer is the doctrine of well-known marks. Where U.S. trademark rights cannot be established based on a producer using a mark in the United States, the doctrine of well-known marks may permit the producer using the mark abroad to obtain relief here by showing that the mark is well known here, even if not used. Now, the U.S. courts have, it's fair to say, not yet developed a coherent understanding of that doctrine. In fact, there is a circuit split between the Second and the Ninth. The Second Circuit believes, incorrectly in my view, that there's no basis in the federal statute for this doctrine, and they hew very closely to the political commitment of territoriality that you find in the Lanham Act and in the Paris Convention. The Ninth Circuit, in its wisdom, has acknowledged the doctrine and has done so as a matter of trademark policy. A case called Gruppo Gigante, the plaintiff had used the mark Gruppo Gigante. Again, you can't imagine how they got giant as the mark for supermarkets, but they did in Mexico. The defendant then opened up a chain of, I guess, big supermarkets in Southern California using exactly the same name, and then tried to stop the Mexican company from using the mark when it crossed the border from Mexico into the United States. The Ninth Circuit says, yes, there is a rule of territoriality. However, that rule cannot be absolute. And they rely on rapid immigration patterns, particularly in Southern California, to support the idea that the foreign mark owner should get protection, commenting, and I quote, that absolute territoriality rule without a famous mark exception would promote consumer confusion and fraud. Commerce crosses borders. In this nation of immigrants, so do people. There can be no justification for using trademark law to fool immigrants into thinking that they're buying from the store that they liked back home. Now, interestingly, based on that reasoning, it would seem the Ninth Circuit simply preferred intrinsic territorial commitments, reputation has crossed the border, therefore so must protection, over the political territoriality that said U.S. rights were different from Mexican rights. But in fact, the Ninth Circuit's approach was a much more nuanced compromise. The district court had also found for the plaintiff, but it had held that the Mexican company should get protection simply upon showing that its store in San Diego had developed secondary meaning prior to the American company opening its store. Now, that's actually all that would be required of an Indiana producer to prevail over the American defendants in Gruppo Gigante, which therefore suggests a complete assimilation of foreign use with domestic use, and therefore a complete elevation of intrinsic territoriality over the political commitments of national borders. The Ninth Circuit said it would not go that far. Instead, it opted for a compromise, what's become known as secondary meaning plus, where you need a substantial number of the American public, of the relevant American public, to be associated with the foreign mark. For the Ninth Circuit, therefore, this slightly heightened standard gives some effect not only to the intrinsic territoriality of protecting consumer association in the areas in Southern California, but also the political territoriality involved that Indiana is not Mexico, and they are different national political units. The opinion is therefore, I think, a splendid example of a court recognizing that there are different types of territoriality involved in trademark law. The first part, the intrinsic part, reflects social and commercial changes without, in fact, the need for much political change. The second, political dimension to territoriality, should be recognized by the court, and it was, unless and until the political machinery itself changes and puts in place different mechanisms. As such, to the extent the courts give any force to the first part of the analysis, the intrinsic territoriality, they may more easily give greater recognition to brands that transcend borders. I should emphasize here, including just what's important about what the court did, it recognized that this approach can actually create a scope of rights that is less than a set of national borders, United Drug, as well as one that is larger, as it did in Gruppo Gigandi. So it doesn't actually have an inbuilt bias either towards global homogenization or to balkanization of markets. One other interesting thing that court did, and then I shall try and sum up, is it did show, I think, one of the continuing challenges for U.S. courts once you accept this slightly more nuanced approach. The concurring opinion in that case also accepted there was a well-known mark doctrine, but he would not have credited the plaintiff's expert survey, which was a study of Mexican Americans living in San Diego County, arguing that because the injunction would stop the defendant from selling to any residents of San Diego, the relevant sector of the public who should have been analysed was all residents of San Diego County without ethnic qualification. And that highlights a point in which I think American courts vary widely. Once you accept that markets are defined by something other than merely political units, how do you define what exactly that public is? That is a question I'll leave for another day or maybe for questions. In conclusion, what I've done is I've referenced three different types of model for revising our commitment to territoriality. So we could first pursue international treaty making, but we see that's only managed very small shifts away from territoriality. Second, we could try to construct unitary rights in regional free trade areas, but we see that the politics gets too far ahead of commerce and society, then the intrinsically territorial aspects of trademark law will reassert themselves and impede the political project. Finally, we can, and this is what I would endorse, without substantially engaging with top-down political reform, our courts could loosen the strings of territoriality by giving voice to the intrinsic territorial aspects of trademark law. That approach, I think, reflects the complexity of trademarks and reflects the complexity of modern communities, but it might, ironically, proceed with greater pace than top-down reforms. Now, as I said, I've only given one example of where I think this could happen, but you can see other potential examples in evolutions in doctrine regarding doctrine of foreign equivalence, regard for online evidence such as foreign websites in assessing distinctiveness, and more nuanced applications of extraterritorial jurisdiction. Developments in all those areas, just as with well-known marks, suggest, I think, that there are judges in the United States, not in the Second Circuit, and hopefully some in Europe, who might lead the way and might force us to rethink trademark territoriality from the ground up. Thank you.
We will have an opportunity to talk to Professor Graeme Dinwoodie upstairs in the reception, but I would suspect that he would also take a few questions now once everyone who's got to go class has cleared the room. And our reception will be up on the third floor, so please join us there. So let's let the folks who need to go to class, and then the die-hard trademark people can stay, and the globalization folks. Will you take it?
Yeah, sure. Very much good question. I'd be happy to try and answer. Yeah, Laurie?
Well, how would you ground, like the Ninth Circuit reversed Dante decision, how would you ground that then in something that's not quite so loose? You know, not just saying, well, it's a matter of policy, if you will. Because, I mean, that was part of the criticism of it, was that it was just kind of, well, fine, it's policy, you just kind of thread it out here.
Well, I mean, it seems to me one thing, the way you do it is a combination of relying on empirical evidence. I mean, so one of the things, the survey, the weight you give to survey, I think, depends a little bit on how much you buy into the concurring opinion criticism, and I think I'm persuaded by his analysis on that question. But certainly you have some regard to empirics. But it's also important to have regard, I think, to broader policy concerns that underlie trademark and unfair competition law. And one of the things that again, doesn't come out in a lot of these cases, but does come out if you look at early 20th century cases, to what extent this is really unfair competition law. I mean, so 6 bis in Paris is very similar to 10 bis. And in fact, I think in that particular case, for example, I think that the sort of equities given the extent of knowledge and the motivations behind what the Southern California company, the Dallas Brothers, was doing, clearly weighed in favor of the Mexican company. So I think you look at the empirics of confusion, of consumer association, you look at some of the broader equities on fair competition. I think you also have to look, and this actually is an interesting question in terms of how you define what exactly the geographic scope is. You have to look also at the fact that trademark law is intended in some ways to promote trade and to expand trade. And you can find American courts having done that in between the 1920s to the Lanham Act in 46, where we had this concept of zone of expansion that the courts developed to allow trade owners to have protection in areas beyond the specific areas of use because we wanted them to grow a little bit. Now, how you balance all of those, I understand there's no mathematical formula, but trademark law is replete with, of course, the non-mathematical formulas. You know, who is the reasonable consumer? Are they significantly confused? There's a substantial number of them that are considerably confused. So I'm not going to give you any more mathematical answers, but I do think it is the type of analysis, the type of methodology you see in that court, particularly I think the concurring opinion, that I would like to see not only in American courts, but also in, as I say, European courts. European courts are being very literalist, and I think there's a lot richer form of analysis that they could start engaging in, and if they look to how American courts dealt with the federalization of trademark law between 46 and the end of the 20th century. Yeah. Right.
Graeme, are there individual judges, and I'm imagining there must be, but let me just ask you, are there judges in Europe with a firm enough commitment to European integration politically and enough expertise in trademarks they would be able to spearhead a movement like this? It seems like there would be.
Yeah, well, the answer is the Dutch, in my view, right?
Certainly, yes.
It is interesting. I mean, there clearly are different. Which gets back to some sort of more critical analysis of judges. In fact, they are heavily informed by their backgrounds, and the Dutch judges have been operating in the Benelux system, which itself was integrated in Belgium, Luxembourg, Netherlands for many, many years. And they don't find it particularly troublesome that their national identity is compromised by being in the Benelux. The British judges are a little bit more sensitive to that. The German judges are a little bit more like the Dutch. There's varieties within the judiciary who I think reflect a different commitment. I think one of the factors that's going to determine whether that kind of agenda can be run is who gets to decide what exactly is the doctrine of European law. At the moment, there is an automatic right of appeal through the European Community Trademark Regulation to the Court of Justice. The effect of this is that last year, this is astounding, you think this is effectively the Supreme Court of the European Union, it heard 110 trademark cases. All right? Those 110 trademark cases are decided by a court that has no trademark lawyer on it. You look at the national courts. The national courts have specialist trademark judges, all of whom have to send their cases as a matter of right to a bunch of people who know nothing about trademark law. I'm overstating slightly. They know something about trademark law after 110 cases, but their expertise is not in trademark law. They have a lot of things to try and handle. They cannot issue dissenting judgments. They have to issue a judgment that represents the views of the 3, the 5, the 7, the 15, whatever. And so you end up with slightly more Delphic readings than you would get from national courts. So one of the things that I've been arguing there's another series of work is, in fact, there's a need to withdraw some of that jurisdiction, and in fact, they want to withdraw some of that jurisdiction for the national courts to be more assertive of when deciding that issues should not go up on appeal because they're already been decided by the court, to basically bring back some of the power to make those decisions to national trademark judges, maybe especially the Dutch, who are able to make decisions based upon a greater reservoir of expertise than I think you see at the ECJ level. But at the end of the day, it is a very political decision, and very few of the judges will admit that what they're doing is a political task. They'll just simply say, well, this is obviously how British trademark law has been. We don't see how it's changed, right? Rather than saying, consciously, to what extent did we cede sovereignty on that issue? To what extent did we reserve sovereignty on that issue? Which would be the explicit way to do it.
Yeah.
Any other questions?
Well, I have one that I'll save for upstairs.
All right.
Brilliant. Thank you so much.
My pleasure.
were describing the court, the issue you were talking about right at the beginning. The